Hello, my name is Jim Crowley, and I will be discussing 3 cases concerning real estate tax liens and a 4th case on a Community Preservation Act appropriation. Our first case is a land court decision concerning the proper procedure in making a tax title assignment by a municipality. The case is Oakledge Properties, LLC versus Hub Realty Company. The case was decided in November 2020. Hub Realty Company owned a 10.5-acre parcel in the town of Randolph. When Hub Realty failed to pay its fiscal year 1975 taxes, the collector made a tax taking which was duly recorded. Years went by, and town officials believed the town now owned the property. The town decided to sell the parcel and published in the local newspaper a request for proposals, an RFP. In response, Oakledge submitted a sealed written bid. Since its bid was the highest, the town signed a purchase and sale agreement with Oakledge. Subsequently, it was discovered that the town did not have clear title to the property because land court never issued a tax title decree of foreclosure. Town officials and Oakledge then took a different course of action. Apparently, Oakledge paid the town the entire amount due in tax title. The Randolph town manager then in April of 2020 signed an instrument called an assignment of tax taking. Armed with this document, Oakledge then filed his tax title foreclosure petition in land court. Land court officials quickly realized there were flaws in this so-called assignment of the tax title. Oakledge and the town of Randolph attempted to resolve the discrepancies and resubmitted the paperwork. One glaring error remained. Chapter 60, Section 52 permits the treasurer to assign a tax title to the highest bidder at a public auction after having given 14 days notice of the time and place of the public auction by publication and by posting notice in 2 or more public places. The treasurer must also send notice of the intended assignment to the owner of record of the parcel at the last known address, not less than 10 days prior to the assignment. Oakledge pointed to the instrument of assignment, which stated in pertinent part that the assignment resulted from a winning bid at an auction and/or in response to a request for proposals. The state form on assignment had been modified to include language about a request for proposals, which is not found in the statute. The land court held there had to be a public auction of the tax title. Oakledge argued that its assignment of rights through the RFP process was consistent with the statute. The land court disagreed. In the court's view, the assignment statute by its terms required a public auction, which is a public sale of property to the highest bidder. According to the court, the town's RFP procedure was not a public auction since there was no consecutive bidding in a competitive manner for the tax title. In the court's view, this so-called assignment was merely an attempt to rescue a failed purchase and sale agreement. Having concluded there was no auction, land court ruled Randolph's assignment of the tax title was invalid and dismissed the foreclosure petition filed by Oakledge.